talk about unlawful dismissal. How much would it cost me to hire a lawyer to go?
As an employee, right, there are few available choices. You can range it from
Welcome to Cerita Hantu Kerja! Today, I have a special guest. You know, in industrial courts, we sometimes have the pekerja as the hantu. Sometimes we have the majikan as the hantu. But today, I'm going to feature a different kind of hantu. The blood-sucking lawyers! Blood-sucking lawyer! Blood-sucking lawyer! Anyways, before we start, you are not as famous as I am. Oh my God! Wow! Maybe you want to tell the audience who you are.
I'm an industrial relations professional. I've done this for many years.
Many years is more than 15 years.
More than 15 years.
More than 15 years.
My first job, my only job, the only thing I know in the world is industrial relations.
Which is always being sued by employees, that would be correct?
I have always been on the employer side.
Yes.
Yeah.
So today we will explore how consultants like him defend the employers, right? So as employees, we know how to work on our defense and offense. Actually here, I have a list of questions that all came from our followers. Now we start with something very simple. So let's say my employer, my boss he did something wrong that went against the Employment Act. What is my right as an employee?
Anything that is wrong in a contract, you normally go to JTK, Jabatan Tenaga Kerja, which is Labour Department. Before you go there, you need to determine right or wrong first.
Yes.
Don't just suka hati masuk. So 11 o'clock at night, Instagram channel Professional Bimbo, ask the question first. After verifying right or wrong, then only you make a complaint. Because perceived injustice is the number one reason people go and file a complaint everywhere. Sometimes it's not really wrong. When companies want to do certain things, employees perceive that it's wrong.
Oh.
Yeah, but it may not be wrong. That's what I'm trying to say.
That makes sense.
All right, so verify first. Then look for avenues. Avenues available, yes. If it's a dismissal matter, go to the Industrial Relations Department. If it's a contractual matter, go to Labour Department.
So at which point that I need to engage a lawyer service?
Normally, it's up to you because you don't engage a lawyer and go for a labour matter or an IR matter.
Okay.
You can defend yourself the whole way through. Especially in labour, normally people don't engage a lawyer.
Why is that?
Because you can self-defend. The court system is a bit more casual. It's less strict in terms of procedures and submissions of documents. But industrial court, yes, it's quite strict. You have to submit your bundles, you have to submit the witness statements and all that. So normally people will hire a lawyer. But at which stage? At the stage where you receive a letter saying that you have to go to court, that's when you engage a lawyer.
So at what point do we go to court? Because to what I understand, when we lodge a report either at JTK or at GPP, right, they will try to negotiate first.
Okay, so rule number one is, upon receiving the complaint, step one, try to settle. If the case cannot be settled, then have to go to court. In the lifeline of a case in labour, it happens very fast. Within 1 month, maybe you can go to court already.
Within 1 month? That is fast!
Yes, very fast. Very fast. Yeah. But if you are going to IR for dismissal cases, it takes a long time. From the point of complaining, that means pekerja, you lose your job, you file your case at IR, to the point you actually go to court, maybe 1.5 years.
1.5 years later?
Yeah, 1 year, 1.5 years.
Like just brewing there lah.
Correct. So just for the sake of the audience, just for you to understand, if you go to industrial law reports right now, and you look at the decided cases this month, these cases come from COVID era.
Which is like 4 years ago.
2021.
3-4 years ago.
And given, yes, there has been a backlog, right? Because a lot of cases happened during that time. But the cases decided now came from that era. So you need to have an indication if you want to file a case at IR, 3 years perhaps to complete the case. 2 years before you engage a lawyer.
2 years before I engage a lawyer. Actually, I read a lot of these cases. I notice if I do not have a lawyer representative, right, or someone who is very familiar with the law, the chances are the claimant will lose the case.
Chances are because of the line of arguments. You have to understand when you go to industrial court. Recently I went. I became a witness. It's not easy because the people there are legally trained to question you. So they do this cross-examination in chief, cross-examination to correct and see whether you will fumble or not during, when
So
you're
is it
testifying.
exactly like how we watch in TV? Like, I object.
No lah, don't have that
Objection.
objection lah. Everybody have a chance to speak. But when you're put to the stand, of course you are nervous. Number one, you're nervous. Number two, time has passed, 2 years has passed. Sometimes you forget the facts. So you cannot really detail out everything nicely. Then the opposite lawyer will ask you a tough question, then you fumble. You don't know how to answer. It looks like you are not prepared. It looks like you don't have your facts.
But I understand, right? They can also represent themselves without hiring a lawyer. But then you mentioned about submitting bundle of documents. So would an ordinary person like myself, who is not legally trained, know how to submit all these bundle documents?
You have to learn lah.
I
You
have to
They will give you a list. You
learn.
have to understand what is required, or you can ask every time you go to court. There are mentions, there are case management, you can go. Then they will tell you next you have to submit this, next you have to submit that. Then you prepare your own.
Actually, I was a panelist in IR Court for 6 years. I remember there was one particular case I was a panel for. The person who wanted to sue the other party filed under the wrong code. And then the case was just dismissed on the spot.
Filing is you have to file under the right section at the right place.
That's right.
So here you are talking about dismissal case, Section 20 IR Industrial Relations Act.
Yes.
So if you file by using the wrong act and you go
Yes.
to the wrong court, then of course the court cannot proceed.
So ideally speaking, when it goes to court, it's better to hire somebody who is legally trained to go, like lawyers, for example.
Okay, I give you another example. The lifeline is so long, right? 2 to 3 years.
Yes.
So how many times do you actually need to go to court? Right? If you hire a lawyer, most likely you as the claimant will only go to court, let's say 2-3 times.
But
in
the
that
lawyer-
But the lawyer is doing a lot of work. The lawyer is going for the mentions, going for the case management. On average, if you see the industrial court case, which you can download online, they show you the dates of each time they go to court. Maybe 12 times, 17 times, that lawyer goes to court to manage this case for you.
Like typically, let's talk about unlawful dismissal. And then at one point, the rundingan tak jadi, then we have to go to court. How much would it cost me to hire a lawyer to go?
I'll give you ranges to hire a lawyer. There are, as an employee, right, there are few available choices. You can range it from say 20,000 to let's say 40,000, but there are also lawyers that works on contingencies, meaning no fee. Unless I win the case, then I take a percentage. Right? I know of certain friends that help out employees also. They say, oh, this is a strong case, but you probably don't have 20,000 upfront to pay me now.
Okay.
You just pay me a bit of disbursements lah.
Okay.
Disbursements like my petrol money, my printing money, just to make sure I don't lose out lah as a lawyer.
So this disbursement, how much would roughly it will cost? Typically
Disbursement, I would say what's fair lah, maybe to begin with 1,000-2,000 ringgit
1,000,
to get you going. Yeah.
Okay. And then when they say I take a share of the award, how much will they take?
They will also kira depending on how much is your salary, because the industrial court awards back wages based on
Correct.
your salary.
Yes.
So if your amount is very, very huge, the percentage becomes lower. Normal 25, 30% is quite normal.
I have another question. Can the employer counter sue? Because you cost me lost 40,000 just by engaging legal services.
That's called claiming for costs.
Claiming for cost.
That means the employee sue,
Yeah.
and then when the employer wins the case, they submit an application to claim for costs. Can also. But if you look at the industrial court trends, they normally don't give a lot. So it's ranging 2,000, 3,000, 4,000. They will bagi balik lah.
So for the poor employee, on top they lose their case, they still have to pay the disbursement and have to compensate the other party.
Chop. When they lose their case, no more poor employee mah. That
Yeah,
means
but if I lose the case and the employer counter sue me for cost,
then they have to pay the cost.
I have to pay the cost.
Correct.
But at the same time, I still owe my lawyer money, right?
If you work on contingency, then no lah.
If it's on
But if
contingency,
there's a fixed fee, then you owe the lawyer's money. So to me is, the legal system should be fair. It shouldn't be, everything sided towards the employee. Because if the employee thinks that he has a good case, then the case should be brought to court. If not, then there has been so much abuse. Everybody just filing the case. Upon I'm not happy with my work, I file the case, hoping to get something.
Yes.
I don't encourage those kind of practice. I personally, I don't like it. Yeah.
It sounds so expensive, like I thought smarter would be just settle out of court.
No, okay. Now I give you the breakdown. Yeah. So you use say 25,000. 25,000. You break it down by 2 years or 3 years. 1 month baru how much? Your lawyer 1,000 lebih only.
1,000 lebih is like a lot way.
1,000. I mean, then you have to consider whether you want.
Not everybody is CEO.
So if you have a good case, then you need to invest in engaging a good lawyer so that you can win your case and get justice for yourself. If you have a 6:30 case, don't engage, don't file also. Try to negotiate something with your employer and get a fair deal.
I understand lawyers, right? They charge by billable hours. So if the more questions I have, like I contact a bit more, does the clock run?
No. If you agreed for a fixed rate already, then there's no more billable hours. It's normally one or the other. Yeah. For consulting projects, if we go out and we bill our clients, we go by billable hours. Law firms, they also do billable hours. They do with their clients. Now, in these kind of cases where you go to court and fight, if the lawyer didn't say billable hours, they say flat rate, then it's flat rate, no more billable hours.
Actually, there's a question from a viewer. Is it true that we should avoid court at all costs?
Not at all costs.
But looking how you are saying it, it sounds so scary, It's like easily like 50K at risk.
Yeah, because
no
you asked
guarantee.
me to put this on now, so I have to make it sound scary a bit.
No, it's really no guarantee to win.
No guarantee to win. It shouldn't be a guarantee to win. A court is where you dispute cases and there shouldn't be any guarantee. If you guarantee, you don't need to go to court already.
That's true,
right?
That's true.
So whether you should be discouraged at all costs, no. Only when there is really a degree of injustice, you should rely on the legal system. But if your motivation is to, a lot of people like to say, I want to kenakan my employer. I'm not happy with the employer. I just want to make them suffer. Then that's not the right motivation. Right? The motivation must always be, I have been unlawfully terminated. Why have I been unlawfully terminated? Because my treatment was unfair, this was unfair. Not perception, not perceived. This way they treat me, fair or not?
You bring up something very interesting. What is fair treatment? Because I have a lot of followers and come and ask me like, my boss used bad words and curse at me.
Okay, case building is what I want to talk to you about. If you believe that you have been treated in an unfair manner, first ask, is it really unfair? You have to ask yourself. Or is it because maybe I haven't been performing well enough, maybe it's not my job scope, or maybe I terasa. If I terasa, it doesn't call for a legal
But
case.
nobody knows whether I terasa or not.
You have to ask yourself that. You have to really examine and ask yourself, is it me being terasa in that situation now? Then, I examine. If it's really unfair, then I start to build my case. Build my case how? You cannot file for a case or argue that you have a case if you don't have anything in writing. So if you start to send some emails to your bosses, oh, I want to clarify with you, why have it been like this? Can I be positioned differently?
So is that the recommendation how we build the case? We start laying trap questions through email.
Not trap question lah. This one betul-betul hantu. You clarify the facts.
I clarify the fact,
Yes.
laying my traps.
You clarify and the response will show you. If your employer has got bad intentions, the response will show the bad intentions. You can smell the bad intentions from
What if
there.
my boss purposely don't want to answer because he doesn't want anything to be recorded?
Never mind. Then every single time when you come across a problem, you have it recorded. That's called case building. When you start to record your facts over a course of, let's say, 6 months, can you imagine how much you have your emails, your phone, your WhatsApp messages? All of this can be used to help you in your case.
How about sexual harassment? Normally, those can be something gestural. How do we record that? Because takkan when somebody tiba-tiba come and touch me, then I go look for a phone. Wait, I record how you touch me first.
Okay, so the very common practice is what? When something happens,
Yes.
okay, normally gestural or visual or whatever to prove sexual harassment, that person, the victim will say, don't do this. I don't
Yes.
like it. Right? That's quite common. Or the victim just shies away because the victim dare not verbalize it.
Yes.
The right thing to do is send a message. Today you did this, I don't appreciate it, I hope you don't do it again. If you have that, that's evidence. Whatever that you said to that person in the corridor, you cannot use it to help your case in future.
Okay, there's another question here to ask. What is the after effect of a legal case? Is it permanently recorded?
Yes, let's say if you have filed an industrial court case before, people have access, there are providers that sells the law reports.
Yes.
If it's a reported case, or cases are reported nowadays, you can go either to the industrial court website, all the cases are there, or you can go to the databases to extract the cases.
But in the industrial court website, they only publish those that are awarded. But let's say if I just go and file, will it be permanently there, the record?
It's not public.
So I'm going to do a flip side. Let's say I want to hire somebody. I want to know whether this one is a troublemaker, want to file cases before or not. Is there a way to go check?
Yeah, of course. The employers can check. So there are a few ways. Number one is there are there are service providers who does verification on
Okay.
this. You have to pay per candidate.
Per candidate.
Right, so they can do all this checking to see whether this guy has a history of filing a case at the industrial court, suing the employers.
Regardless whether he win before or not.
Yeah. So it can give you the whole summary. Even if there is a pending case now, that person can identify for you. So that's a service provider. Or you can do your own DIY process to find out lah. So you can, maybe seek help from your lawyer, your company's lawyer, go to the database, they will have a subscription. Just key in this person's name and everything about this person, if he ever filed a case before, will be there.
And it's the same for employee. If I'm looking for a job, I want to know whether this company was sued before for compliance before or not. Will it be the same?
You can do that. Normally companies, nowadays even a lot of news are reporting,
Yes.
right? So you can see, just Google the company name. If there is, an unlawful dismissal suit happen, they will say, Syarikat ABC.
But
lost a
normally
case
these are case hangat-hangat.
Okay lah. Nowadays the not so hangat one is also reported. Yeah, I see a lot of reports nowadays on unlawful dismissal. Safest bet, if you want to have a clear view of everything, industrial court website. That one free of charge. Go in,
Yes.
search, and get what you want.
Just to let you know, it's mp.gov.my. That is the website.
Yes.
And you go under the awards tab. That's where you can find all these
Correct.
courts
Then
awards.
there's a breakdown. You can choose non-compliance, dismissal.
That's right,
whatever,
that's right. Okay, next question that we have here. How does the law address situations where an individual is solicited or restrained from practicing their lawful profession? Sounds so complicated,
Yeah.
this one.
So this is a situation where I left the company and then the company tell me for the next 1 year or for the next 2 years, I cannot work in a similar industry, in a
Correct.
competitor
Yes.
and all that. Okay, so this might come as a surprise, but this is called a restraint of trade situation.
Yes.
This is not enforceable in Malaysia. So when you have these clauses in your contracts, normally it's meant to be a scare clause.
It's just to scare you lah.
But it's applicable in other parts in the world.
Not in
So Malaysia, you
Malaysia.
cannot do that unless, okay, let's put a twist here. Unless there is consideration. Consideration meaning there's an exchange of something. So I say I want you to be restrained, but I'm willing to pay you X amount of money, and you accept.
This is interesting. Unless there's a separate contract to
Correct.
restrain you.
So you leave the company, we pay you your gaji, your bonus, everything done, and then we say now we want to sign a contract with you, confidentiality lah, restraint lah, and all that. And in exchange of you signing this, we give you a sum of money, and you sign. Then you cannot dispute that because that is a separate contract altogether.
Interesting.
Yeah. So normally for very high level executive sensitive positions, they usually do that. Or the other way is they put you on garden leave.
Yes, that is a very common one, garden
Yeah.
leave. Okay, now, when we go against the contract, right, we go to JPK, correct? For unlawful dismissal, we go to JPK. Now, there's a different kind of situation. What if the company offered me a job, I sign and return my agreement, I tender my resignation, then 2 weeks before I report to work, the new company retracted the offer. They rescind the offer. Okay, I am not a pekerja yet, so I cannot go to JPP nor JTK. So what do I do?
Normally, what's common out there is the employee sign the offer and they don't turn up to work.
Yes, but it's
Right.
also quite common, what?
So when
the boss U-turn take away our offer a lot, okay?
See, no choice. I've been putting on the employer hat for so long. I only speak the employer language. If, let's say, that situation is where the employer rescind the contract, first and foremost is you need to understand the relationship between the employee and the employer.
Okay.
If you sign an offer letter and then you're only going to join on, let's say, 1st November,
Yes.
you haven't officially joined as an employee, right? So you cannot file a case at IR because the workman relationship under the IR Act only starts on your first day at work. So there's no unlawful dismissal until you start work. Okay, then what can you do?
What
Can you
can I do?
try to claim for labor to say that I want to have notice? You have a long argument there also because the employer will say that your contract haven't started. My advice to you would be there is still this aspect called the civil claims, right? The civil claims, that means you need to engage a lawyer for your civil claims. You need to be able to prove what have you lost and how have you lost. So for example, I lost out because I have tendered and now I don't have a job. That's one way of you losing out. Quantify that. Speak to a lawyer, get those kind of advice to go under the civil avenue. That would be better. I'm not the best person to tell you civil, what can you claim for and all that, but there is that avenue available.
I have to engage a lawyer lah to sue the employer under civil court.
Yeah.
Right?
Yeah.
And how much would that cost?
Semua duit, ah?
Of course lah!
Ask the lawyer.
What I understand now, again, the process takes years and the compensation is not much.
It's not worth it because if you stumble upon this kind of situations, right? I'm thinking now from an employer's point of view. If the employer ever come to me and ask me, we need to rescind the contract, what would I recommend the employer to do? I would always recommend for the employer to consider at least pay off the notice period.
Pay according to what the termination clause is as per the notice period.
Right, so let's say that's 1 month or 2 months, which is quite normal. Just pay off the employee 1 or 2 months and make sure you speak to the employee, make sure you achieve mutual consensus because these kind of cases are very grey. And you certainly don't want to go to civil to defend this case. You're spending a lot of time, a lot of energy as an employer to go and focus on these kind of cases when it's not worth a lot, that's not a deal breaker in any way. Might as well you invest that money and say, resolve this carefully.
So it's possible, right? The process of going to sue my boss yang tak jadi tu is much more expensive than what is going to compensate to me.
It's possible.
So it's like a lose-lose situation.
It's possible, yeah.
Then all your hantu bosses will be free, scot-free lah, like that.
That's why I say it's better if you go and negotiate with your boss, the soon-to-be or no. How do I put this?
The boss yang tak
The boss
jadi.
yang tak jadi, negotiate to say, hey, I've already resigned from that company. This is not very fair. Can I demand for something? I kid you not, companies would consider giving that notice, at least that notice.
At least 1 month, I would think.
Yeah.
Yes.
Then you take that notice and cepat-cepat find for another job.
Now, how about on the flip side? Since you always represent employer, what if now I want to reject offer?
Then guarantee the employer will come against you to claim for notice.
What if I don't pay?
Okay, if you don't pay, the employer have a choice to file for this case.
Oh,
Same thing.
They the one spend thousands of dollars just to come after me lah, because they tak puas hati.
Same thing. Okay, so principally and morally, it's two different things. If you ask anybody morally, would they go after? I don't think anybody would. But principally, because maybe this has been happening too many times in the company, too many people doing that. It's the same like abscondment. Right? Abscondment, people abscond every month. Just resign, don't even resign, just disappear.
Yes.
Companies will come to a point where every month I have 10, 15, 20 people absconding. I have to do something about it.
But then it's easy. I just go to GTK to file. I don't need to hire a lawyer, no cost.
Yeah, but what if let's say they want to go the extra mile, they want to go civil? They can also. So I know of companies that, okay, for this period of time, in these 6 months, any cases, I must go civil.
So I have actually, I heard followers come and message me. They said that they were blacklisted in CITOS because of this. Is that true?
Possible if they file it to CITOS. There are also a lot of financial information providers out there. Right now, there's a new one. I saw their product a couple of months back. It's just IC number, no? I don't know how they get past the PDPA stage and all that. So I can key in your IC number and I can
On
see
the
whether
website?
I have to buy. I have to buy some credits like CITOS. Then I key in your IC number and I can check whether you are bankrupt lah, you got cases lah, different price for different things. Right? So it's quite a new product and they are selling it to the employer market. Yeah.
Okay, now I have another question I want to ask. Domestic inquiry. From what I understand, domestic inquiry is like an indoor court within the company. So under these kind of circumstances, are we allowed to bring in an external party to represent us, like a lawyer, for example?
Not recommended. There's no law to say you cannot, but not recommended. This is like your home affairs, you gaddle with your wife. Why do you want an external party? When you gaddle with your wife, you want to call your neighbors to come and mediate that situation for you, no, right? So you want to try to settle it within the household. That's the purpose of a domestic inquiry. If you want to get external parties involved, it's like a court really. It's like a court before the dispute happens.
Yeah, but what if I am someone who is not very good in argument, and my company is that how you use it, berating? He keep hantam I during the DI, and I left speechless. I'm not good at arguing.
Yeah.
So if I felt like I'm being bullied in the DI,
Okay, so yes, there is this lopsidedness because employers are normally more competent. They've been through the necessary training to run a DI, to ask a question. But the employee who's affected may not have gone through all this, so they don't know what's going on.
Yes, so
the best thing is get assistance from somebody within the company. The employer cannot say no to this. So get a fellow colleague to help you out. But if you say you want external party, I want to get my father in to help me, normally the company will say no. Or if your company is unionized, right?
That is a good question. Can they deny my right to bring in external counsel?
They will deny.
Are they allowed to?
They are allowed to. They are allowed to say that this is only internal. But if let's say you mati-mati, you say you won, and then you say if you don't allow me, then I claim constructive dismissal, I think this is unfair or whatever, then it doesn't stop them from bringing in their own lawyers also. External party versus external party. You see, then it doesn't make sense anymore, right? To have like two external parties fighting over a case internally.
While they can deny my right, but it also does not stop me from pursuing the case further, right? That's all that they have asked. It has been very interesting to get to know these cases. Then before we go, is there anything you want to share with the audience?
Yes, actually tomorrow is a big day for us. I think this would be aired a bit later. But,
yes.
I'm happy to have you at the opening of Eden.
Yes.
Only on the 9th of October, we're going to have our opening.
So let's talk about Eden. What are you guys all about?
Industrial relations consultants, focus on employers.
Only employers lah.
But I do some employee work as well on an unofficial basis, more so for assistance.
For an employer to engage your services, let's say I have an employee come and sue me for something very small matter. The recent case of Prophet Muhammad plus the
public holiday.
Public holiday. And they did not replace my public holiday. Very small matter like that. But the employee went to sue me for it. You guys can represent and defend me at the Labour Office?
Can, but our services normally is very much advisory. That means advisory would put you in a situation where that shouldn't even have happened. So the idea, my concept of industrial relations is different from the 1960s, 1970s. A lot of people back then, and I would agree, back then is a battle. Industrial relations was a battle, a bank table with trade unions and all that, fight. That was how industrial relation was many years ago. But now, I have shifted my mindset. It's all about prevention of cases happening. So a good strategies when it comes to industrial relations is how can I prevent this case from going to court?
Of course.
From an employer side, right? Or how can I prevent these disputes? I want to make a change in the contract. I want to change your working hours. I cannot just taro and change the working hours. I must think about how can I change so that everybody is comfortable. When everybody is comfortable, no disputes, that's the measurement of my success. That's how I position Eden as an employer-centric but no disputes.
Just like the old saying, prevention is always better than cure.
Always better. And you think about it, I mean, this very much is for employees, right? Before we shut the camps, I also want to say something. No, I believe, right, employers, after representing them for so long, they're not as hantu as they are.
Really?
Yes.
You sure or not?
Sure, 100%. I ask you something, who wakes up from bed and have the motivation to do the bad thing? Nobody wants to do that. Right? Even the lawyers representing them, they also want to do a good job. Everybody wants to do a good job. The issue here is everybody's angle is different. The perspective is different. And if it's not communicated properly, people don't understand. That's where the disputes happen. It's not because of bad intention. 90% of the time. Workforce
That's why I always advocate for workforce harmony. So ladies and gentlemen, so it's true. We always avoid court at all costs because at the end, I will tell you who will win. The blood-sucking lawyers only will win.
No. Again, correction, not blood-sucking. Very fair and reasonable. Only file your case when you have a case.
Only file the case when we have a case. With that, we bid you farewell, okay? Thanks! If you like this video, don't forget to like, share, and subscribe. Bye!